Toby. Tommy. Son.
Toby.
Toby. Sonny. For the second defendant.
Yes, my lord.
Yes. I'm waiting for you.
My lord, we have for the first defendant a housekeeping application.
Okay.
Dated the 24th day of January 2025, seeking to regularize our reply to the claimant's final written address, my lord.
Yeah, filed on the
24th day of January 2020. 24th day of January 2025, my lord.
Oh, okay. What is the application for?
Lord, we are seeking for extension of time within which to file our reply address to the claimant's final written address and a deeming order, my lord. Subject to your lordship's convenience, we are ready to move same. Is not opposed, my lord.
Yes, the claimant and the second defendant. Do you have any objections to that?
I do not have any objection, my lord, for the claimant.
I have no objection from the second defendant.
All right, Mr. Oguru. Okay. All right. It's granted as read.
As the court
pleases.
Yes, it's granted as read.
Yes, my lord, the second defendant also has a housekeeping application. It's just on the 9th day of January.
Just a second.
As the court
hold on.
As the court pleases.
Yes. Is it the second defendant?
Yes, but the second defendant. It's an application dated and filed.
Okay, go ahead.
Okay, my lord, it's dated and filed on the 9th day of January 2025. It is essentially to seek leave of the court for the second defendant to file its reply brief. And then also, there's a deeming prayer. My lord, parties have been served and there is no objection.
It's granted as read.
As the court pleases.
Yes.
My lord.
So are we done?
My lord, I seek to bring to your lordship's attention that yesterday evening we are served with claimant's additional list of authorities, which essentially is which is a reply to our reply, because the claimant went into argument and cited authorities. My lord, the claimant does not have a right of reply under the rules of court. The claimant does not have a right of reply after we have served him with our reply.
Where are my rules?
My lord, we urge your lordship to. My lord.
Let me come. Yes.
My lord, we urge your lordship to discountenance the said claimant's additional list of authorities. However,
we'll take everything and then
as the court pleases.
We'll take everything.
As the court pleases.
My lord,
we'll take everything and respond to that in the judgment.
My lord, I'm getting to a point, my lord. If your lordship is minded to countenance the list of authorities, we require a short time to orally respond. Just a few minutes to respond to the authority side.
Hello.
I'm sorry,
We are
can
talking about today.
proceed to do-
Hello? This is Samuel
The audio is not helping matters. Wait. Who is talking to me now?
Huh?
My Lord, I don't know who is interrupting, my Lord.
This is
Please call Williams for me. Let him come with my rules. Felicia, tell him to come with my rules. I'll let him come fast. Yes, I'm listening to you.
My Lord, I made an application, my Lord. I submitted that if your Lordship is minded not to discountenance this list of authorities, then we require a short time after we adopt our addresses to respond to the authorities cited.
We have two options here. Is that this matter, you come in, everybody will respond, or we adopt and then we respond to it in the judgment. Because the essence of it, we have to do justice to everybody before us.
My Lord,
I don't want anybody to feel left out.
My Lord, I do not see what the issue is here. What we have filed is an additional list of authorities. We cannot serve it skeletally without stating the principle for which we are bringing in the authorities. That's what we have done. We haven't made any extra arguments. And the man who is complaining filed a reply to my address, which is over 25 pages, a question of benediction being longer than mass. But I'm not taking objection to all that. The matter is for adoption today, and he has not even adopted, he's attacking my process. I think they should proceed to address or to adopt. When I adopt, if he has anything to say, he can say, then I do my response. It's an additional list of authorities. The Supreme Court allows it, the Court of Appeal allows it. That is the essence of Section 36.
It's allowed. It's allowed. It's allowed to supply additional list of.
But not to make argument, my lord.
He has served you, has he not? Well, I will look at it whole and then I'll respond to it.
As the court pleases.
When you are adopting, you should draw my mind to that. I'll put it on record. And then in the judgment, I'll address the issue.
As the court pleases.
I don't really see a problem here. I suppose that was Chinedu talking to me.
Yes, my lord. My lord, I needed to point out that I'm going to address it. I needed the court's permission. That's why I was pointing it out.
No, when you after you adopt, you can address me on that. I'll take it down now.
As the court pleases. My lord,
we'll take it down, we really have a problem here.
As the court pleases. My lord, the first defendant filed a final written address dated the 20th day of November, 2024. Twentieth day of November 2024, my lord.
Day of December 2020.
November, my lord. 20th day of November.
Okay.
My lord, we most humbly adopt. We most humbly adopt the.
I'm listening.
We most humbly adopt the final written address as part of our agreement in this case, my lord.
Huh?
My lord.
Was there any replies on point of law?
Yes, my lord. In response to the claimant final written address, we filed a reply address dated the 24th day of January 2024, which was just regularized by your lordship. And we most humbly adopt the same reply address as part of our argument in this case, in urging your lordship to dismiss the claimant's case against the first defendant.
Felicia.
My lord.
Yes.
My lord, in response to the authorities cited by the claimants, the claimant has cited 3 authorities in his additional list of authorities. Our submission, my lord, is that the case of Eroku and Eroku and Buhari and INEC are inapplicable.
What is the date on the additional? What is the date on the additional list of authorities?
It's dated the 19th day of February 2025. 19th day of February 2025.
The additional list of additional list of did we receive that, the additional list of authorities? I'm sorting. I'll just put the rules here. Come and show it to me. I can't find it. Just a second.
Claimant's additional list of authorities filed on 19th February.
I have seen it. Now,
as a couple.
Our source submission is that the case of Eroku and Buhari and INEC are inapplicable to this case, as they were decided based on the Notary Public Act, which we have submitted in our reply that is not applicable to the witness statement of oath of the first defendant. Going further, my lord, the case of Atiku against INEC number 2 is clearly distinguishable from this case and actually supports our position, which we have made in our reply, to the effect that affidavits are distinct and different from witness statements on oath. And the claimant cites this authority in his further attack on the witness statement of oath filed deposed to by the witness for the first defendant. And the case of Atiku and INEC was decided on Section 110 of the Evidence Act. which provide for
Yes.
which provide for the circumstances and conditions for admission of foreign affidavits.
Yes.
The case dealt with affidavits, and when foreign affidavit can be admitted in Nigerian courts and not witness statement on oath.
Yeah, Chekube.
My Lord, the Notary Public Act
Disturb your sleep.
was not decided, was not considered at all
You
in
know,
that authority.
about that virtual court sitting. I don't already link them up.
Who is talking?
My Lord, the Notary Public Act was not an issue in that case, and the case is therefore cited out of context and should be scrutinized by your lordship.
Inspector, you locked that door. Open it for her.
My Lord, that case never provided that the
Where
Notary
was that
Public
mess coming from? Is the one?
My Lord, that case, Tico and INEC, is not an authority at all that the Notary Public Act of Nigeria applies to a notary public appointed in Texas, United States of America.
Okay.
Therefore, it has added nothing to the argument of the claimants. Moreover, my lord.
All right.
Moreover, my lord, the claimant had a declaratory relief, and the law requires that he must prove his case. I cannot rely on even admission from the defendants.
All right. Are you done?
If I may, my lord, to summarize our case in our final written address, our case is very simple. The first defendant did not employ the claimant. The letter of engagement is before your lordship. The document that shows that it has been the second defendant that paid the salaries of the claimant is before your lordship. The letter of resignation is before your lordship. The claimant addressed it to the second defendant. There is no doubt in the mind of the claimant that the second defendant employed him.
My lord, with all this, I will object to this style of advocacy.
Oguru. 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 Can you hear me? Mr. Chooks Oguru, can you hear me?
Is he objecting, my lord?
Thank you, Felicia. Mr. Oguru, can you hear me? Can you hear me? Mr. Anyaso, are you done?
No, my lord. I'm about done. My lord, as I was saying, the document before your lordship shows clearly that.
Yes, my lord.
Yes, Mr. Oguru. Hold on,
I
Mr.
can hear
Anyaso.
you,
Mr. Oguru, what do you want to say?
Is my lord hearing me?
I can hear you, Mr. Oguru.
It's not details.
I can hear you, sir. It's my lord.
Can I continue, my lord?
Let's simply regurgitate. Can my lord hear me now?
Now I can hear you, Mr. Oguru.
Even
Talk
now?
to me. Now I
I'm
can
speaking.
hear you.
You can hear me, my lord?
Yes.
Okay, let him conclude. Let him conclude. There's no point. So since we're having glitches, let him conclude so I can adopt too.
Yes. Go ahead, Mr. Anyaso.
Yes, my lord. My lord, what I was saying, my lord, is that the documents before your lordship.
You said that summarize wholly, the first defendant did not employ the claimant, the second defendant pays the salaries and emoluments of the claimant.
Yes, my lord. And the claimant also resigned. When he resigned, the letter was addressed to the second defendant. His secondment to ExxonMobil Iraq, the contract of secondment, the first defendant name was not mentioned there at all. So there was no doubt in the mind of the claimant who employed him. We urge your lordship to, based on the document before your lordship and the evidence of the first defendant witness, to hold that the claimant was employed by the second defendant, not the first defendant, and dismiss the case against the first defendant, my lord.
Yeah. All right.
the part of the second defendant,
Yes.
I know the second defendant's final written address is dated and filed 26th of November 2024. I know we adopt the argument contained therein and urge my Lord to dismiss with substantial costs the claim of the claimant.
Yes, I'm listening.
And now the second defendant also filed a reply on point of law to the claimant's final written address. The said reply on point of law is dated and filed 9th of January 2025. And now we urge, we adopt the argument canvas theory and urge my Lord to again dismiss with substantial cost the claim of the claimants. Now, all our arguments are contained and will not adulterate because of the glitches. And Lord, we are grateful.
Thank you.
My Lord, in response to the written addresses of the defendants, the claimant filed a composite written address on the 18th day of December 2024. 18th day of December 2024, we adopt our arguments therein as our submissions in this case. Is my lady with me?
Yes.
Okay. We also filed an additional list of authorities on the 19th day of February 2025, 19th February 2025. We urge my Lord to hold that the claimant has proved his case on the preponderance of evidence and is therefore entitled to judgment. My Lord, it's our contention that the first defendant has no competent evidence before the court. The first defendant's counsel has attempted with pomp and pageantry. The first defendant has attempted with pomp and pageantry to distinguish affidavit from written statements on oath. My Lord, our simple answer is that whether affidavit or written statements on oath, both must be sworn before an officer. Both must be sworn before an officer authorized to take depositions. A fortiori, the Evidence Act, the Oaths Act, and the Notary Publics Act are all germane. The first defendant gives the impression that a written statement on oath deposed in the United States of America need not comply with the laws of Nigeria to be competent. My Lord, that is a gratuitous insult to our jurisprudence. It's a gratuitous insult to our jurisprudence. Any deposition to be used in a Nigerian court must comply with the laws of Nigeria. And we have given an authority. We have given an authority to that effect. My Lord, we have not used any law, any authority carelessly. And the protagonist of our jurisprudence, the Supreme Court, in Article 9 NEC, which my learned friend has sought to discount or devalue, says that a witness deposition, and I'm quoting their lordship verbatim et literatim, a witness deposition made in another country cannot be automatically received as evidence in Nigerian courts. We got our independence as far back as 1960. We cannot be tied to the apron strings perpetually to foreign jurisdictions. I therefore urge your lordship, in view of the superiority of facts and law marshaled by the claimants, to find and to hold that the entire defense to this action has tested positive to the virus of failure, and their destination must be the Bermuda Triangle. I pray your lordship to enter judgment for the claimants. We know the defendants were up against, but the law has always been fiat justitia, red column. Let justice be done even though the heavens fall. And Ogutade JSC in Amechi and INEC said that when justice is done, the heavens do not fall, they remain in place. Thank you, my Lord. Thank you, my lady. I am true.
All right. Thank you. Okay. I think everybody has adopted.
Yes, my Lord.
So, huh? What was that?
No, I didn't say anything.
All right. Have they adopted? They have. They have. So all parties have adopted their final written addresses, the replies on point of law, and a short address by the parties on the additional cases that were supplied, and everything is duly adopted. So the parties will be communicated with a date for judgment in due course of time within this quarter.
Court pleases.
Thank you very much, gentlemen.
We are grateful to your lordship.
Thank you very much.
Thank you, my lady.
Thank you. Have a nice day, gentlemen.
You too, my lord.
Thank you. Thank you.
Thank you.